appeal in the matter of W in brackets a child.
Yes, Mr.
My lady, I appear on behalf of the appellant in this matter, together with Mr. Fiddy, who sits behind me, and the mother, who sits at the back of court. Mr. Sampson, King's Counsel, and Miss Brown appear on behalf of the father, who sits at the back of court. Ms. Mayor, King's Counsel, and Miss Miller appear for the local authority, and Miss Chadwick appears as a child, accompanied by her solicitor, who takes instructions from the children's guardian, Miss Guichard. Can I just begin, my lord, by explaining the fact that my learned friend Miss Mayor is sitting to my left in order to accommodate a hearing difficulty that she has, and just to be clear, that's why.
No problem at all.
Thank you very much. My lord, you will be aware that this case concerns an appeal from a decision of His Honour Judge
Can we
Weston.
just deal with one housekeeping matter?
Yes, of course.
We don't have a bundle of authorities.
No.
Supposed to.
No. The message came through to, I think, Lord Justice Baker's clerk, that the legal propositions that were relied upon both by the appellant and also by the other parties were agreed at the bar. And so, in keeping with the practice direction, we read it quite strictly, and we didn't provide an authorities.
We read it unusually strictly, but not wrongly strictly. No, I think we didn't find anything, speaking for myself, who would have been more likely to need it than others, that I felt, I'm ambassador to the full authority for that. So well done.
Thank you very much.
We were just surprised because it's not the usual position.
No, we read the direction quite closely, so that's why we did what we did. So thank you very much for that. I should say as well, in terms of another matter of housekeeping, yesterday we passed through a recent decision that was handed down last week in the case of Riyadh.
Yes, thank you.
We do have paper copies for the court if that would
No,
be.
well, certainly if copies reach me, and I think that's my lord and my lady. Yeah.
Thank you very much.
Right. Off you go.
Yes, my lord. So this appeal concerns a child who was born on the 29th of November 2020 and is now aged 3 years and 2 months. As I say, her parents are at the back of court. She is an only child, and she was born as a product of a stable relationship between the parents for 10 years. The local authority issued proceedings in relation to this child on the 7th of October 2021, with His Honour Judge Weston taking control of the case and granting an interim care order on the 8th of October 2021, which means that the child has lived away from her parents now under an interim care order from the age of 11 months. At the moment, as we stand here today, this case has been before the court in terms of active proceedings for 2 years and 4 months. And so obviously the balance of time that this child has spent away from her family is greater than the time that she spent with them following her birth. I should say as well, by way of update to contextualise the appeal as to where we are at the moment, you will be aware from the order which is in the supplementary bundle at page 56 to 58, an order for Honour Judge Arthur from the 29th of January this year. This case is relisted for consideration following this appeal on the 11th of March, with a view obviously to deciding the next steps in relation to how this case is dealt with here, but also to make real progress, one would have hoped, in terms of a resolution risk assessment, which has been directed for the family. Very sadly, I have been instructed today that the initial screening report for that assessment, which was due tomorrow, is not ready and has not been provided. I'm told that there are difficulties with legal aid funding, and so yet again there will be more delay imported into this case in taking it further, which I'm sure the court will appreciate is extremely regrettable and extremely difficult for the family who are suffering with the length of proceedings.
Yes, that is. We're certainly very alive to all the problems caused by delay in a case of this kind, and the delays are, of course, very regrettable.
Just before I leave that topic of delay, if I may, the court will be aware from a chronology that was prepared in the core bundle that at various stages during the course of the litigation history of this case, there has been repeated delay, both in terms of the instruction of experts, questions going to those experts, and at least 2 aborted attempts at a fact find, I think in October of 2022 and again in May of 2023. When the case came for the fact-finding hearing in the July, there was additional delay, which I know the court is alive to, due to the fact that the evidence concluded at the end of July. There were closing submissions in August, a headline decision given by the judge on the 6th of October, but no written judgment for just over 7 weeks after that, when obviously the decision was given to the family, and it's that decision that we seek to appeal. So that is the difficulty that the case has sadly suffered with so far. If the court requires further information as to the reasons for that delay by the judge in providing the written decision, then we can provide that. It's a combination both of delay within the court system and pressure of work and personal matters for the judge.
Thank you.
Can I just ask Mr. Bow, if I may, at this early stage, if your appeal succeeds, what course will you be inviting this court to take?
There are two options that we have essentially put before the court. The first is for this court to take the view that the threshold is not satisfied on the evidence that you would have before you. The second is that the case is regrettably remitted for rehearing before likely a different judge, because the judge who dealt with this is now elsewhere and for other reasons. I think it's got to be right that we accept that this court might be in some difficulty in interfering with the decision in respect of whether or not threshold is crossed, simply because of the amount of evidence that is not before you, which is contained within the trial bundle. That said, we do say that there is a sufficiently problematic approach taken by the judge to key evidence that means that in actual fact this court may well feel able to say that on balance, taking into account the particularities of this child's medical history and also the dearth of research material reaching to the issues of bone fragility, that the threshold is not satisfied.
Well, your case before the judge, or I think, it was that taken at its highest, taking Dr. Sharp's evidence at its highest, the threshold wasn't crossed.
Yes, I think that...
You didn't put it like that, or Julia didn't put it like that, but that in essence was your case, wasn't it?
Yes, I think it was a situation whereby, at its highest, because the research material in relation to this particular difficulty is relatively limited, because there was compelling evidence, we say, in respect of the lay evidence both from the parents and their extended family, and because of the fact that this child had competing medical issues that raised the possibility of bone fragility, that on balance the judge was not able to find that the threshold was crossed. What we say is that regrettably the judge did not give appropriate or sufficient weight to other material that would have been relevant when reaching his decision. He effectively held up the medical evidence and placed the lay evidence up to it without giving it proper consideration.
Yes, well, you'll be coming to that point in a moment, but just taking the question my lord asked you, you say, which is the case, that we don't have obviously the totality of the evidence, but we do have a pretty full, as far as I can see, uncontentious summary of the evidence that was before him.
Yes. And certainly the areas where the experts...
Well, on the areas which were clearly decisive areas in the case.
Yes, yes. And the point is made at the beginning of our document, paragraph 39, that effectively the judge's evaluation of the evidence turned exclusively pretty much on the expert evidence without...
Yes.
And we make
And
that...
largely on the evidence of Dr. Sharp.
Yes, largely on the evidence of Sharp, which we say in and of itself, the treatment of that evidence, there are some difficulties when one looks at paragraph 102 in the judgment, which is just a simple recitation.
I won't ask you to trail your decision, your submission to
Yes.
go on.
So just before we go on to the detail of your submissions, I'm just looking at the case management order that you referred us to. And the screening report, which now, as I understand it, the screening report is the equivalent of is it the equivalent of a viability assessment to see whether or not it's appropriate to move on to a full risk assessment, and that presumably is to consider whether, notwithstanding the findings as they currently stand, consideration can be given to rehabilitation of either
That's
parents.
my understanding.
Is it my understanding, therefore, that no application for a placement order is currently before the court?
There isn't. And no, there's no such. My understanding is that the options for the judge are either rehabilitation to care, or I think, if I could turn my back to check this, potential assessment of the foster care in relation to special guardianship.
Right.
May I just turn my back?
Oh, I'd be grateful for that information.
My lady, that's my understanding.
Yes,
on
so
behalf
if
of
I
the
just
local
meant- so-
authority.
There's active consideration. I know no decisions have been made, but there's active consideration to rehabilitation in any event.
There is.
And otherwise, the consideration would be for remaining with the foster carers who've been with for over 2 years.
Yes.
But in the context of a special guardianship order.
Yes, and I think I'm right in saying that the extended family will know that the maternal grandmother was an intervener in the proceedings.
Yes.
None of the extended family, I think partly as a consequence of their experience in the proceedings, feel capable or able to put themselves forward, and you'll be aware of the associated medical difficulties
Yes.
that attached to the maternal grandfather.
The case management talks about a viability assessment of the maternal great-grandmother. Eileen Owen. I'm mentioning her name, obviously.
Yes, I think that she's still a potential live prospect.
Yeah.
So it's rehabilitation, the foster carer through an SGO, or the maternal great-grandmother.
Thank you.
But as I say, I don't think, in fact, that's where I was going to turn my back about, as to whether or not anyone has actually met with the family yet in relation to the resolution style assessment. I don't think that really has begun.
So the screening report's simply not got off the ground yet, is that?
No, and so when the case is returned, it's due back in on the 11th. I don't know whether an application will be made in anticipation of that to resolve the funding issue, but we are basically where we were in January.
So why is this one of these? Across the assessment for equal shares, local authority weren't volunteering then to pick up your
No, and I think,
portion.
well, I
given
don't
the
know, to
delay
be
in this
fair, that they've
case?
been asked. No, I don't think that has been mooted
Seems-
with them as yet, but that's perhaps something we will discuss.
Does
This case has not been conducted with the urgency. This is not criticising anybody in front of us, but it doesn't seem to be conducted with the urgency which is required under case management principles, which the President has recently reinforced.
And when one looks at the chronology of events, there are multiple C2 applications themselves which take some considerable time to resolve before we have a clear trajectory as to where the case is going next.
Thank you very much. I'm sorry to interrupt, but
No,
that's most
cool.
helpful to me.
Thank you.
Yes, but just, sorry, one point I meant to mention at the very beginning. We're going to rise early for the short adjournment will rise at 12:50, and depending how we're going, we may if necessary resit at 10 to 2, or if there's no time problem, we'll simply resit at 2.
Thank you very much, Ronald. Thank you. The court will be aware that there is effectively one ground supported by 5 subheadings, all of which overlap to some degree, in that the general criticism that is made of the decision of His Honour Judge Weston, King's Counsel, is that the treatment of the evidence and his approach to that evidence was flawed. It's accepted and acknowledged in the skeleton argument that we have provided that there is an inherent difficulty that usually attaches to these sorts of cases in dislodging findings made at first instance by trial judges. But what we say in this case is that it's relatively unusual because there is a complete lack, as I have previously mentioned, of any real evaluation of the credibility of the lay witnesses in this case. And so we say that overall the court can be satisfied that the judge approached his task incorrectly and in a way that was not in keeping with the general principles which are recited both in his judgment and are well known. If I can begin first of all with the first ground, which begins in the skeleton argument that we have provided at page 28, effectively that the court gave insufficient evidence of the fact the child had suffered an accidental fracture of another bone at around the same time as the shin bone fractures, and that the court erred in failing to consider this fact as part of its analysis as to whether the child had abnormally fragile
Sorry,
bone.
you're allowing your voice to drop slightly.
Forgive me. And that the court erred in failing to consider this fact as part of the analysis as to whether the child had abnormally fragile bones. It's a relatively short point, but effectively what we say is that it was plain to the court that the child had sustained a complete femoral fracture to her thigh bone. It was accepted by everybody who was in the case at the time, as well as by the judge and the local authority, that this was an unusual accident from a low-level fall. And the judge was on notice of the fact from Dr. Olson's report that although he could not comment radiologically on the possibility of low bone density, which is in his report at paragraph 6.8131, one may argue that 3 leg fractures per se in a child who has recently started weight bearing raises significant suspicion that the bones were themselves insufficient, which is at 131. Also, this pattern of injury was identified as Dr. Olson as being unusual in that the fractures are seen commonly as being caused by axial loading weight bearing, and fractures of the type seen in the shin bones often being called trampoline fractures because of their typical mode of causation in older children. What we say about this is that the judge had identified this fracture as a relevant consideration at paragraph 74 of his judgment, which is at page 103 of the decision. He says, I also have in mind that this is a case in which nobody disputes that the child sustained an accidental femoral fracture whilst in the care of his step-grandfather. There is no suggestion that he acted other than appropriately when this accident occurred. He doesn't, however, when looking at the possibility of bone fragility, which begins at 104 onwards, give any consideration, it seems at all, either to the fact that the child in close proximity suffered an additional fracture of a large bone at around the time when the shin fractures were said to have been likely caused, or indeed gives any consideration to whether or not that has any probative value in the case overall when evaluating the circumstances relevant to bone density. The only time that the issue of the femoral fracture is alighted upon by the judge is when he reaches the consideration of pain response.
And Mr. Fiddy, in his closing submissions, had relied on the fact of the accidental femoral fracture as a factor pointing to bone fragility.
He did.
Paragraph 11D.
Yes, and I think I'm right in saying that the point was also taken up on behalf of the father in the closing submissions that they submitted as to how unusual it was that there had been such a significant fracture of such a, I think the longest bone in the body, was the way it was put. And so, but also taking part the point made by the local authority that the option is open to the judge as to whether or not he wishes to factor that into his overall analysis. But the fact remains that he actually said that he had it in mind, that it was a matter of relevance, something which was of consideration when looking at the overall analysis, but was effectively parked.
I mean, if that really is what the local authority is saying, it is quite astonishing that you would say when there's an innocent fracture of the femur, to say it's up to the judge to decide whether it's relevant in determining what's happened in relation to 2 other fractures that occurred at roughly the same time.
The judgment has a number of places where the judge identifies that he has not repeated certain evidence or has considered the totality of the evidence or has taken the view that he's not going to repeat things for being at risk of making the judgment overly bloated. But what we say about the femoral fracture is that plainly was a point of relevance, and he identified it as being relevant. And the complete absence of it in the analysis, we say, is problematic and goes in some part, in large part, to identifying that the judge hadn't given proper consideration to all of the surrounding evidence or the wide canvas. In terms of the second ground, which begins at 28 to 29 of our skeleton argument, this effectively is that the court had erred in failing to consider the cumulative impact of the possible causes of the child's bone fragility. Instead, the court analysed each possible cause in isolation from the other, and in doing so, evaluated the evidence in compartments rather than as a whole. The judge posed the question to himself at paragraph 52, page 98 of the judgment, that the significant issue that he needed to consider and arrive at, the significant issue that I need to consider and arrive at conclusions on arise from whether the child had bone fragility arising from her prematurity, including low birth weight, for an extended period in the NICU, TPN feeding and problems with feeding on discharge from hospital. Charitably, we have included the reference to feeding as to include the omeprazole point, although it's not specifically identified, but the judge does go on to consider omeprazole, and we have assumed that's under the banner of feeding. what is important, we say, about this is that there was not only expert evidence but also lay evidence that went to this particular issue in the case, because the family members had given evidence to the court and been questioned about the nature of the care that had been given to the child upon discharge, the nature of the difficulties that had been experienced with regards to feeding issues, and how the parents had accommodated that and what that they had done to treat it. We agree with the proposition made by the father's team in this appeal that a central aspect of the case was the combination of the factors that the judge identified at paragraph 52. And it's right to say that he properly directed himself in relation to how he was supposed to treat that evidence. And you'll see under the pages dealing with the recitation of the law, which begins at page 90, that the judge specifically references at paragraph 38 at page 90 that evidence cannot be assessed in separate compartments, the case of Route T, that he'd had regard to the judgments in L and M, particularly paragraphs 46 to 58, which set out all of the general propositions relevant to these sorts of cases, and that when he reaches the conclusion of this part of the judgment at paragraph 109, which is at page 112, he specifically says that he does not consider that prematurity, healthy feeding, and unethical use, when considered individually and collectively, was such as to contribute to or cause fractures by reason of bone fragility. That is the only place on the analysis undertaken by the judge at which there seems to be a nod to the fact that these issues must be considered collectively. There is nothing in the way either that the judgment is structured, but also more critically in the way that the evidence is placed alongside one another to give the impression that the judge at any given time felt that he was dealing with all of these issues specific to the medical history of this particular child, and which was relevant to excluding her from the Malcody study, which she would never have been a participant because she wasn't a healthy child, that he dealt with those matters together. What appears to be the case is that in relatively short order, and this begins at page 104, he takes the topics, prematurity, feeding issues, and omeprazole, and effectively parks and parcels them off. He deals with them, he says they're not relevant, and he puts them to one side. And we say that that is a fundamentally flawed approach when looking at what is effectively a very complex medical picture for this particular child. For example, he did not consider how one factor may impinge upon or affect any other factor. And an example of that would be, we say, the fact that although the judge discounts at paragraph 83, this is at page 105, prematurity and the child's time on the NICU and TPN as being likely to have caused bone fragility, the point that was always made on behalf of the mother was that there is an association between these different areas, not necessarily causation, but an association linked to her medical history and the omeprazole use, which may give rise to the possibility of this child suffering with bone density issues. He does not, as a consequence of the prematurity, consider the child's exposure or absorption rate, for example, to omeprazole. Dr. Sharp, in her first report, referred to the study of Gunuk-Sekaran et al., which had identified that infants under 6 months can be exposed to amounts of omeprazole, perhaps due to immature enzyme capacity. And also Dr. Sharp, in her oral evidence, added that in the case of infants, their capacity for hepatic metabolized drugs may differ because of the state of the liver.
Could you just give me the reference to the Dr. Sharp's report?
Yes. So Dr. Sharp references...
No, sorry, you said Dr. Sharp had said about that, but you said one of the other doctors as well before you
Forgive me,
mentioned
it's
Dr. Sharp.
both Dr. Sharp, but she referred to a study by...
She referred to an earlier study.
Yes, the earlier study. And,
Do you try to have the page reference for that?
of course, yes. That's at 170
117.
170, my lord. Part way down the page, and that this study urged caution in the use of PPI in infants under 6 months of age.
This is the Grunasaccharin report.
Due to the pharmacokinetics of the drug.
And where oral evidence, where is that referred to in the judgment
The oral evidence, forgive me,
or in the submission?
is that's at page. It's in the judgment at 110, paragraph 102L. Dr. Sharp accepted that infants have a differing ability to metabolize hepatic drugs, and that they clear at different speeds than a mature child who has been exposed to more things.
Yes.
What we're saying is that the link about the age of this child, which was effectively put to one side when prematurity was discounted early on as having any impact, was not adequately picked up by the judge and then dealt with alongside the other matters which he then went on to consider. And we know that Dr. Shenoy had flagged in his report that the child in this case was on omeprazole for over 7 months at the time of presentation to hospital, which can cause a risk, an increased risk of fracture, and that's at 149 in the bundle. There is, we would say, at this crucial section of the judgment, because of the particularity attaching to this child in terms of her medical history, there is no time taken by the judge to adequately reflect upon the ways in which these different aspects relevant to her were operating together or were interrelated to assess the likelihood of whether or not she did in fact have an issue with bone fragility at the time when she was presented at the hospital. And I would say, and my submission is on behalf of the appellant, there are no signals within the judgment of this part to identify how the judge collectively considered these issues critical to this particular child. We say that he fell into error because he dealt with the constituent parts of the child's history rather than putting them alongside one another, which is obviously completely contrary to the proposition that he had identified and reiterated at length under the relevant law section of the judgment. Subsection C of the ground of appeal is that the court...
So is this one ground 3?
It is. I'm moving quite quickly. I hope that's all
No,
right.
that, speaking for myself, and I think for my lord and my lady, these are good skeleton arguments. We see exactly what the issues are. You're not losing anything by taking them quickly.
Thank you very much.
No, I was only getting confused because I'd regarded them as 1 to 5, not A to C, but it's...
The only reason I've done that is because it's one ground with subheadings, but
Yes,
back
no,
to number
fine,
3.
keep going, yep.
That the court placed excessive weight on the evidence of the expert paediatrician regarding the likely pain response of the child after the injuries were sustained, and that the court placed insufficient weight on evidence that may have explained the absence of an obvious pain reaction, therefore placing the burden onto the parents. It's got to be right, and the appellant concedes that the judge, when looking at the relevant law, recited paragraph 11 of BR, which is at 193 of the judgment, and that the judge is entitled, in cases of this sort, to take account of the fact as to whether any caregiver can provide information or evidence relevant to any pain reaction that they may have noticed by a child at the time when injuries were sustained. And I think we also have to accept that Dr. Shenoy gave generalised opinions as to the likely pain response of this child at the time when the shin fractures were sustained. And that's at paragraph 11 onwards in his report at 157 in the court bundle. What we say, however, is that when the judge turned to look at this, and his analysis begins at 112 of the judgment.
Sorry, is that paragraph or page?
It's page 112, paragraph 111. Both, yes. The judge expressed it as there being an expectation that the parents should be able to have, and this is at paragraph 118, the expectation of a history being provided by those involved in primary care, consistent to what Dr. Chinway advises, is not to reverse the burden. What we say, however, is that the only evidence upon which the judge evaluated the issue of infliction was this point about pain response. And he elevated it, we say, to the only point of critical evaluation in a way that was wrong, because he didn't consider the very clear and consistent evidence that had been given not only by the parents, but also by the extended family, who were of course involved to some degree at varying times in providing care to this child during the course of the fracture window. We say that in simply zoning in, if I can put it that way, or underscoring the absence of a pain response by parents on account of one, he effectively positioned the judgment around that fact to the exclusion of anything else that was relevant. This point about evidence from other family members. The evidence from the extended family was consistent with the parents, that they hadn't noticed that there was any pain response from this child during the relevant period, which alerted them to a possibility.
To the extended family, this is the grandmother and the step-grandfather.
Yes, who gave evidence about this. They didn't identify that there was anything during the course of the evidential history of the child that effectively alerted them to there being a problem. That was consistent with the account given by the parents. They too had not identified that there was a difficulty. And yet the judge, when evaluating under a different heading of the judgment, which is the identification of the perpetrator, specifically rejected an invitation from the local authority to find that the extended family members were being untruthful with the court. And that can be found at page 115, paragraph 124. So, for example, in terms of the maternal grandmother, partway down that paragraph, the judge says, in terms of their evidence to the court, I consider they were each generally doing their best to assist the court. I reject the local authority's submission that in the manner they allege, the intervener, the maternal grandmother's evidence was in any way disingenuous or lacking in credibility. I do not accept that she was not forthright with the court, as alleged by the local authority. I do not accept that the local authority's submission that any inconsistencies in her evidence amounted to matters that render her evidence unreliable. And similarly, the same point is made over the page at 116, paragraph 126, when dealing with the evidence of the step-grandfather.
You have left out the last two sentences, 1, 2, 4, which qualify
Yes.
what he said to some extent, although it's a little bit difficult to see exactly what he is saying.
Well,
But it's clearly intended to some extent as a qualification.
well, potentially, except that a strong element of rose-tinted spectacles and overwhelming desire to reiterate the positives, even if that was something that the judge thought was relevant, it hasn't undermined his assessment of her credibility, which is effectively that she was an honest witness, I would say. The same point is made with regards to the other intervener over page 1, paragraph 126. I do not accept the local authority submission that any inconsistencies in his evidence amounts to matters that render his evidence unreliable. The difficulty here, we would say, is that when evaluating all of the evidence that existed on this issue of the pain response, the judge focused upon the parents' evidence in isolation and didn't, we say, undertake a clear evaluation of how or in what circumstances they were being disingenuous or dishonest or were failing to be open with the court with regards to this aspect of care. Because when one looks at the other evidence that existed and which was drawn to the judge's attention at the time in the closing submissions, and which are set out in our skeleton argument at paragraph 52A, which is at page 30, except the judge has not dealt in the judgment with the manipulation of the legs at the time of presentation to hospital. He accepted that there was a possibility that the fractures themselves from Dr. Shenoy's evidence might have been silent, but decides that that is not likely to be the case, but doesn't explain or delve into the evidence given by the parents as to whether or not what they are telling him is likely to be right, and doesn't deal with the fact which is recited as an accepted fact at the beginning of the judgment of paragraph 73, and that's at page 103, compelling features of certainly my client's background that may have assisted him in evaluating the evidence with regards to pain response. And in particular, I'm drawing attention to page 103, subparagraph E, that the mother and the maternal grandmother are teaching assistants who have devoted much of their lives to caring for vulnerable children, which is a point that I will come back to later. F, that the family's evidence was they were all extremely careful with the child because of her early start in life, and the evidence by the mother was that they'd been given some training as to how to deal with her following discharge from hospital on account of her prematurity. And G, the quality of the contact, which is described both as exceptional and exceeding good enough care. Because certainly in terms of this family, the type of care that was being offered was thought to be exemplary. And so we say that here, what the judge has effectively done, it's right to take account of, but he has exclusively fixated on the evidence of pain response, or the lack of an account, without putting it into the round with everything else. And it's that evidence of the lack of account of a pain response that the judge has effectively constructed the entire analysis as to whether or not these injuries were inflicted. Because even on the basis of the medical evidence, even in circumstances where if he were of the view that having taken the evidence of the medics in the round, that the child likely didn't have a bone fragility, he has not gone on to consider the likelihood, based upon the parents' evidence, as to whether or not they would be people who would inflict the type of injuries described by Dr. Olson as being necessary to create the injuries in healthy bones. And that doesn't appear to have been done at all. It's all based around pain response. And what we say is that this linear approach, which has been taken by the judge, is exemplified at paragraph 117, which comes with the presentation of the presentation after sustaining shin fractures, where,
You're on page 117 or para 117?
forgive me, it's at page 117, forgive me, page 117, paragraph 131. This comes at the end of the section on identification of perpetrator, where when the judge, and I'll come on to this on the last round, looks at the evidence of the parents, he says that in any event, the portrayal of family things, by the family of things being perfect, cannot be accurate, given that the child has sustained shin fractures, which I found to be inflicted as being caused by unreasonable care. There's no evaluation of unreasonable care at all in this case, or any deficits identified by the parents as caregivers. As to how it was that they may well have inflicted these particular injuries in healthy bones. Perhaps then if I can turn to the fourth round, subsection D, which appears at 30 to 32 in our skeleton argument. And this is effectively that the court has erred in accepting the evidence of the expert pharmacologist in circumstances where it was based on a research study from which the child would have been excluded, and the court failed to analyse the significance of the child's exclusion from this study on the likelihood of omeprazole contributing to bone fragility in her particular case. So the first point that we would make about this is that it's absolutely plain from the reports that were provided by Dr. Sharp before she gave her oral evidence that there are inherent difficulties with the research material that exists in relation to this particular issue. The research material is relatively scant in relation to children, and also there are various aspects which, to some degree, contradict one another. So, for example, or are relevant to particular children. So, for example, Dr. Sharp, at 167 of her first report, page 167, talks about the pharmacology of omeprazole and states that the rates of absorption of omeprazole are erratic, do not follow classic pharmacokinetic principles. She, as I've already alluded to, mentions the Gunexekaran research at 170 in her report. She also refers to Anderson, another study from 2001, which showed a greater exposure of infants under 5 months of age to the same doses of omeprazole, possibly due to reduced ability to metabolize that drug. She says at 169...
Not completely clear on the likelihood of effect on bones in infants.
Yes. Yeah. So there's that signal there. Also at 171, specifically examining the information available on the use of omeprazole in preterm neonates, the evidence is even more unclear. And under the comments section, comments and opinion section of her report at 173, she makes the point that while omeprazole in adults is uncommonly associated with the risk of bone fracture, the data in infants and children are conflicted.
Sorry, I'm being so. Why did it assist your case to say that the evidence was full of uncertainties?
Well, in terms of the
Because your point is that there is clear evidence that omeprazole does constitute a risk factor.
yes, what I'm saying is that in terms of we are saying that, but what I'm saying is that the judge, in terms of his approach to the analysis, was alerted to the fact that there were these issues that were relevant to his overall evaluation, but he hasn't actually analysed them when it comes to that section of his judgment. It's completely right. We're saying that there's an association between the use of omeprazole,
Right.
the prematurity of the child, the fact that she was in hospital for a prolonged
Your
period.
point is really that you can't start to qualify that clear risk factor, that clear association, by sophisticated analyses of exactly when it occurred, or but largely that is actually what the judge relied on, because what I might call the detailed or granular detail is much less clear than the overall picture.
Yes.
Yeah.
And although the judge cautioned himself about relying too heavily upon research material, and although there was a challenge made to the doctor relying on the Malcody study, we would say that he has simply reiterated the evidence that was given by that particular expert and not gone into the detail as to how and in what circumstances that research study would, if applicable, apply to this child, and where it can take him so far that the limits end.
The fact the child's excluded from the study is a point in your favour.
Yes.
Yeah.
But he has focused more upon whether it was right for the expert to be able to rely upon that study rather than the actual analysis of what comes out of that study, and also the other evidence in relation to the medical factors of the child, we would say. Because when one looks at paragraph...
I'm sorry, I'm being slow. There's no problem about them relying on the study.
No.
The problem is about relying on some particular things you might draw out of the study.
Yes.
Yes.
Yeah. But at paragraph 102 which is where the focus of the judge's analysis on this point really is, which is at page 109. He identifies that the expert Dr. Sharp made important points some of which are relevant to the child. So, for example, high risk point B, that the expert accepted that the child had omeprazole for over 7 months, putting into a higher risk category of those prescribed the medication for a duration of 150 days. Similarly, G, that the Wang.
I mean, they're all just a rag bag of points. These aren't. They aren't. It isn't structured. These
No.
points go this direction. These are. Well, this is the point we draw from them. It's just here are
Yes. And that's-
13 miscellaneous points.
That's short. That's the shortcut to the points. Yes, that I was making. But they're a jumble of. It's a jumble of points that were made both by the expert and contained within the evidence and the study. But then when one gets to the inevitable section where that would then be striated, and you would pull out the individual strands and you would balance them against one another, or think about how they affect this particular child, or how far the study can go in assisting the court in evaluating the bone fragility of this particular child. It doesn't happen. It just focuses in the main upon whether or not the expert was permitted to rely on Malcody, rather than going into any particularity as to how my lordship's phrase, this rag bag of various points, applies in this case. He talks about how the expert has acknowledged those points relevant to the child, but doesn't really explain how the expert has utilised that acknowledgement when saying that it's still relevant to rely exclusively and fully on the Malcody study in circumstances where the child would never have formed part of it in the first place. And it is taken back consistently to the median age in relation to children of 3.8 years suffering some form of fracture, without having regard to the fact that this child, from the start, was at risk of a higher fracture rate. When you look at the paragraphs 103 onwards,
Can I just understand one thing about this? Obviously, the median age simply means out of the total number of cases found, if there were 100, 50 were below and 50 were above. So that really doesn't tell you very much. But there is a slightly more specific point made at C. The data demonstrated in children who have been treated with PPIs from an early age did not demonstrate fractures until after the age of 1 year. Is that? I didn't see where the judge got that from.
I think I know, but can I just turn my back for a moment
Yes.
to check? It's in
I
the,
didn't see it in the report. Obviously, we haven't got transcript of the evidence, but
no, I think it's taken from the study. So
Yes.
at 203, page 203, figure 1.
figure 1.
Which is, yes, applies to children with PPI only, as the child in this case was. But I think the point I'd make more generally about paragraph 102, it's lots of untethered points made at various stages, both from the report of the expert, the oral evidence of the expert, and the Malcody study, which are then jumbled together in a list, but then which aren't actually extracted and thought about in any meaningful way for this particular child. And what I would say about that, obviously, the court must take into consideration the expert evidence. It doesn't rate more highly than anybody else. There's no magic in the evidence from an expert, but the court isn't a silent partner when it comes to actually evaluating that. And it was incumbent upon the judge in this case to give real consideration to how this complicated picture actually applied in this case in helping him resolve what was one of the crucial aspects of the case. Because even in circumstances where he may have concluded that there was no bone fragility, the possibility of an association is still extant between omeprazole use and the bone fragility, and he ought to have gone on to have considered the lay evidence alongside it in reaching his conclusion on infliction. But what effectively I suppose we're saying about this section is it doesn't really disclose to the reader how it is that he has reached his ultimate conclusion.
I suppose it's the case, isn't it, that if in the Malcody study, what I want to read figure 1 is that there were no cases of fractures reported in the first year. One doesn't know what weight to give to that without knowing how long the infants in the first year had been on it. If, take an extreme example, all the infants had only been on it from 11 months, clearly there wouldn't be a fracture in the first year because it doesn't weaken your bones straight away. One just doesn't know what proportion actually were people who were in a similar position to the child in this case, who'd been on it at the end of the first year already for 10 months.
And also in circumstances where the children in this study were healthy. And
well, that's a separate point. I get that point entirely.
Suffered with, because there are a number of reasons, obviously, which I know tonight as to why this child would have been excluded. Her fracture is one.
I've got that point, yes.
But no.
But just looking at the Malcody study in itself.
Yes.
Yeah, thank you. Thank you.
I'm just going to move on to the last point that we have.
We're not complaining.
No. Which is the fact that the court placed insufficient weight on the wider evidential canvas in this case, in particular the total absence of risk factors surrounding the parents or wider family. The court failed to analyse this evidence in coming to a finding that chin fractures were inflicted. I've touched upon my other submissions at this point at various stages, but we say that there is a significant deficit in this case about his treatment, the judge's treatment.
Sorry, you're letting your voice drop again.
Sorry,
A significant what?
Deficit in the way in which the learned judge dealt with the lay evidence in this case, and that the point made or the submission made at the very beginning of the skeleton when we talk about the grounds, that the whole of the case effectively turned upon the court's evaluation of the medical evidence reads true. And that's at page 27. At various places, the judge will say that he has considered the lay evidence, but there are obvious parts of the judgment where it is critical that he does so. He does refer, under the relevant law, to the fact that the lay evidence, or the parental evidence, or caregiver evidence in cases such as this, is of the utmost importance, and that the court must give proper consideration to the credibility of the witnesses when trying to uncover precisely how it is that these, when dealing with the local authorities case in finding that the threshold is crossed. I've already referred to paragraph 73 of the judgment, which we say is relevant because it appears twice. It appears not only in the substantive judgment handed down by the court in November, it also featured, if I can describe it as this, in the continuation judgment that was given by the judge, which was handed down shortly before, I think, the weekend that this case was due to be heard. So that the application to not proceed with the fact find was heard in May. The judgment for that came out on the 20th of July, which was very shortly before this case started on the Monday for the substantive fact find. And in that judgment and in this judgment, the court sets out.
So have we got that up then?
Yes, it's in the. It's on the 20th of July. It's at 222 of the bundle.
Oh, I see. Yes, thank you. Yep, thank you. And this particular paragraph appears where?
The point was just being made to me that it's identified as a draft, but it's the only version of this judgment that was circulated. Paragraph 73, we say, is relevant here because the items which the judge has accepted as facts are important and go beyond what one might expect to see in certain cases where there's an absence of any red flags that gives rise to a concern for risk factors. Specifically the points that I've already mentioned. But in terms of E, that the mother and the maternal grandmother are teaching assistants and have devoted much of their lives to the care of vulnerable children, we say that that in itself brings some colour and hue to the case for the judge in trying to determine the type of people that are caring for this child. It's their first child, born out of a loving and stable relationship. Mother was anxious, as a new mother would be, not to the point where there were any difficulties with her caregiving. It's noted that at D, there is no evidence of the mother's mental health being unstable, but there was a reference to the fact that she had experienced PTSD following the child's birth. But when one looks at the judge's evaluation of them as parents, he speculates as to whether or not they actually, this is at page 117, paragraph 130, the mother and the father each did not identify any issues of caring with Eloise. I do wonder whether caring, forgive me, I mean the child there, I do wonder whether caring for the child was not as easy as they say they saw it. I don't understand where that's come from in terms of his evaluation of the evidence. The mother was undertaking a substantial amount of childcare whilst at the same time having to manage her own anxiousness and her PTSD. It's accepted at 73 that there were no issues arising from the mother's mental health relevant to caregiving. The father was working nights, and whilst this was an established routine for him, I do wonder whether he was overly tired as a result of this and his understandable desire to be fully involved in caring for the child. I do consider that each of the parents may be minimising the impact that caring for her was having on them. Now that is completely untethered paragraph. That is not related to any evaluation of the credibility of the parents. And when placed alongside the accepted facts in relation to the standard of care that was being provided to this child at paragraph 73, together with the fact that there were no issues arising from the mother's mental health, it's out of sorts. It doesn't sit well within the evaluation of the case. And it comes only at the point of the identification of the perpetrator. It does not come at the point where the judge is evaluating whether or not, even in circumstances if he was entitled to find that there was no bone fragility, it is likely that these parents inflicted the injuries in the way the local authority sought to prove. And we say that that is a fundamental problem, as indeed, before we get to the issue of identification of the perpetrator, there is a signal, we would say, as to the way the judge was dealing with the evidence overall at page 114, paragraph 120, where he talks about the evidence regarding pain response. And at 120 says, I have very well in mind that set against the medical evidence is the very positive wider canvas and the absence of the type of risk factors identified in VR. And we say that that seems to suggest that the court is placing the evidence of the family against the canvas of the medical evidence, which is wrong, which is the point that we were attempting to draw to the court's attention in the case of RIAR at paragraph 34.
That's the one that's been ended up, is it?
Yes, it's just the decision of Lord Justice Peter Jackson where he identifies that it's at 34 it's wrong to describe medical evidence as the canvas against which other evidence is to be considered. What appears to be the case here is that the judge has effectively looked at the medical evidence, has put the lay evidence in part against it in an attempt to dislodge it, and has arrived at a conclusion which appears to be not anchored to any evaluation of the credibility.
Well, he made a finding that the child did not have bone fragility at 118 on the medical evidence alone.
Yes.
And having made that finding, he accepted that, he took that as a fact, as a given
Yes.
when assessing the rest of the evidence.
Yes.
your point is that was the wrong approach.
The wrong approach. And that sadly that is a way that he, despite setting out very clearly the relevant legal framework, the judge has departed from it when actually it's come to analysing the evidence overall.
It's the error, you say, it's the error identified by Mr. Justice Charles all those years ago in KDL,
Yes.
which is part of a litany in LLM.
Yes.
Medical evidence may point one way, but the judge, looking at the totality of the evidence, is entitled to come to a different.
Yes. And although throughout the evidence, throughout the judgment, the judge repeatedly refers to having had regard to the totality of the evidence or having in mind relevant evidence, it doesn't appear that that is actually the case, and that he hasn't gone underneath those slogans, if I can put it that way, to actually deal with what it is that he's being asked to deal with, which is the local authorities case. And they almost read as markers to insulate against criticism. There's nothing beneath it, if I can put it that way. When one drills into the way in which the judge has reached his ultimate conclusion. And I should just say, under this ground, as well as the same point I made previously about the logical approach taken to the extended family evidence and the caregivers, the parents' evidence in this ground, and also the point which was made in closing submissions, which wasn't dealt with at all, but was dealt with when evaluating the evidence of the step-grandfather, was the reaction of the parents upon finding out that the child had been injured. It's dealt with by the in terms of the intervener, that he acted entirely appropriately by raising the alarm, and the parents, upon being made aware of that injury, immediately reacted and took the child to hospital, I think within the hour. There's no account given to that at all, nor is there any account given to the fact that in page 61, which is the chronology, the judge, I think it's right to say, replicated this chronology in the judgment, but you'll see there at the third entry, this was an entry taken by the doctor at the time of the presentation at hospital. Mum states that there wasn't any previous fall that she's aware of, and if she did, she would have brought her to hospital. And that's the evidence that the mother gave in court as well, and that was drawn to the judge's attention in the closing submissions, and he hasn't dealt with that either. So all of the positives that one might expect to see being dealt with haven't been specifically addressed as part of the totality of the evidence when deciding the local authorities case. And we agree with a point made on behalf of the father at 292 that by failing to properly examine the import of the lay evidence, the judge deprived himself of the ability to consider the inherent likelihood or otherwise of the fractures being inflicted. I've gone at a relative pace through the submissions that support the appeal. I don't know if there's anything else at this stage that you would like me to address more fully.
You haven't talked about the evidence about the mechanism for how the injuries might have been sustained.
In terms of the mechanism point, I think that comes back to our ground where we talk about he hasn't considered the lay evidence about whether or not these parents would be capable of or would be likely to have, in healthy bones, undertaken a mechanism that would likely cause the injury.
I mean, there's a very striking phrase in the radiologist's report about trampolining.
Yes. And also,
the judge does acknowledge in the judgment that the jumper, if there was bone fragility, the jumperoo
yes,
could have caused it, and
yes,
the radiologist says these are trampolining injuries.
yes, that there are type associated with.
Identical fractures
It's
in
done
the same place on the shins.
Yes.
I mean, there's no mention in the judgment about any of that. About normally one would have expected perhaps to have seen something in the judgment about how it could have happened?
Yes, there's no evaluation of the mechanism at all.
Because we know when the more common metaphyseal fractures, that's so often changing nappy, exhausted, frustration, yanking the baby's legs. But that's something that gets dealt with in the evaluation of what's going on in the household.
Yes, and
But
that's why.
But we don't know what was going on in this household from this judgment, apart from the fact that there were no red flags and they had a loving and supportive family and were in a stable relationship.
Yes, and that's why the paragraph I took you to, which seems so stark, where the judge speculates or postulates as to, I wonder whether there was a stress on the family, and that comes within the context of identifying the child as being relatively healthy. But there isn't anything in particular about the way in which care was being given to this child in that period, which would account for the mechanism which is described by the expert. There's nothing. There's the evidence in relation to weight bearing, which was provided to the expert with the photographs and the videos.
But that just predated the window.
Yes. But there's nothing else in terms of whether or not the parents have concealed or the family have colluded in order to say that there was something that took place which they're not being honest about. That's specifically rejected on the credibility, the evaluation of credibility of the extended family. But there's nothing in terms of drawing together a picture which might lead the judge to conclude that the injuries were inflicted in a way that was set out by the expert or likely to be set out by the expert. It just isn't there. I don't think there's anything else that
Thank you very
at this
much.
stage was going to mention unless I can be of assistance.
Thank you. Mr. Sampson,
Well, thank you.
we've obviously read Ms. Brown's skeleton argument, which unsurprisingly makes broadly the same points as made on behalf of the mother. And it's really up to you whether there are particular points that you wish to amplify or points that haven't fully come out.
Thank
But
you.
I think most of the points in the skeleton argument were either been made by Mr. Bow or come out in the discussion with the court. So
Well, I'm
approach it
grateful
on
for
that basis.
indication. Thank you. May I check, and I may have misheard, my lord refers to Miss Brown's original skeleton argument.
Oh.
There was also a skeleton argument prepared
It's your
by
skeleton.
Miss Brown and by me.
Oh,
I
I'm
just
so
wanted to check
sorry.
my lord has both.
well, I'm sure I have both.
Thank
but
you.
Looking at just now, in order to say what I've just said, I turned up that version. I have also got your quite right.
284 is the one I'm thinking about.
Yes,
Thank you.
and of course it's not the same as the earlier one, but it's not all that different either.
No, it's not. My lord, may I've been listening obviously carefully to my lord, my lady's exchanges with Mr. Bow, and if I may just pick up a few points.
Of course,
the first
no,
of which
we
was the
were
inquiry.
not trying to stop you in any way, but merely just give you an indication.
Thank you. To pick up on an inquiry raised earlier by my lady, which is the question about the viability assessment, I'll call it that, or screening assessment by resolution. I'm grateful to my instructing solicitor, given the delay in this case, and I know there will be a real concern about that. That order resulted in the instruction of Tracy Carboni, I think it is, at resolution. The screening assessment is a tool that's often used to look at people's aptitude for the full assessment. An email was sent out by those who instruct me, and forgive me, no, I'm going to get this right, was sent out by the resource itself. And a response was received from the local authority. Some over 3 weeks later. I do not, on behalf of the father's team, make any criticism of that, but effectively what that response from the legal department said is we're still waiting on instructions from our client. We can't take an executive decision about prior authority supplemental funding. That said, I am
Sounds
told...
that you are making a complaint about that.
That said, I am told that it has now been resolved and the local authority is to pick up the tab, the surplus, and it's just starting. But it's built in. It's another example in this case, unhappily, of delay.
Mr. Bow indicated that if needs be, we could be assisted with the delay in the judgment? Can you give that information, or do I need to go back to Mr. Bow for that?
In terms of the delay in the judgment, the reasons for it.
Yes.
My lady, I can only assist to this extent. An indication was given by the judge at the close of the evidence that he would be assisted by swift closing submissions. I have to say the advocate's assumption was that that was to minimise delay in an already protracted case. The advocates were aware that the judge had had certain health issues which affected his ability to type, which were weighing heavily on him in preparing this judgment and others.
Yes, I was. I didn't pick Mr. Bow up, but you phrased. I thought they might matters of a confidential
That's
nature,
why I
which
raised
were
it.
best
Yes.
addressed. We were best informed about confidentially, at least at first.
My lord, to my mind, given that that was stated in open court, it was known.
Yes,
I
I
wanted
see.
to put
Well,
my lord's
no,
mind
well,
at
anything
rest.
that's been said in open court, you can tell us, and we'd be helpful to know. But if there's more that counsel would tell privately,
Yes.
I think at least in the first instance we should be told it privately.
Thank you. Beyond that, my lord, I am aware that there were then chasers to find out when this might be received. That resulted in the decision being handed down, or rather notified, by email in October. But there was then another significant wait for
Do
the
we have a
reasoning
copy of
behind
that
it.
email in the bundle?
My lord, my lady,
We've prepared a chronology of
you.
the litigation history effectively from this point, which we can circulate and hand up if that would be of
I think that would
assistance.
be very helpful.
It sets out the inquiries made by the advocates and the responses from the judge.
If we could have that to our clerks really straight away,
Do that.
and then we can look at it over the short adjournment, and if there are any questions about it, we can raise. But it's the reference to the judge's health issues, all you were told in open court was the problems with his ability to type.
Thank you. My lord, I will pass that. I think it was a private email, in fact.
Oh,
It
I
is
see.
known
Well,
about this particular judge that there was an issue, but that email will
Well,
be passed to my lord.
well,
you.
thank you, it'd be helpful.
My lord, in relation to the delay issue that I pick up from that, of course, the problem is, while we were grateful to receive notification of the decision in October, where what follows is a bespoke risk assessment, until one knows the parameters of what that assessment will do, by way of a reasoned judgment, effectively, it doesn't really ameliorate the delay at all. We also made the point, and I make it somewhat cautiously, that it may be, and I venture this only as speculation, frankly, that some of the lack of detail in the judgment about the impression formed of the parents may be the result of a very significant delay before pen is put to paper or fingers to computer. I say that because to inform the court, both of these parents were in evidence for half a day each.
Well,
My lord,
sorry?
both of these parents were, each of these parents were in evidence, were giving oral evidence to the court for half a day.
Yeah.
That clearly does not come through if my lord, my lady, look at the judgment, in the judgment itself. Taking, if I may, the grounds swiftly, with an eye to the clock, the point that we make perhaps is
Okay.
this. This is a linear judgment. I accept that judgments are necessarily linear in some respects, but where they traverse the evidence, they need, my perhaps figurative speech, to leave doors open which need to be left open to look at the rest of the evidence. That is the purpose of the RE-T guidance. It is multifactorial, and the reason I raise that is this. What the judge does in a variety of paragraphs when looking at the three differential reasons, which individually or collectively could lead to bone fragility, is he closes each door. Then comes, as my Lord Justice Baker has noted, to the final paragraph where he then looks back at all three and closes the door. And that door remains closed when he then goes on to consider the parents' evidence. Effectively, the stage is set by an analysis of the medical evidence. I'll take this shortly, my lords and my lady. The relevant paragraphs of the judgment are paragraphs 84, 93, and 106. Each of those closes the door on the differential reasons for bone fragility. Before then, there are several paragraphs that look in a little bit more detail at how he proposes to address it.
84 is prematurity.
Yes,
93 is feeding.
yes.
And what was the last one?
And the last is the
106.
omeprazole. That is the lengthy rehearsal that this court has already examined with Mr. Bow of Dr. Sharp's evidence.
And then one 110.
And then following that, my lord sees a fairly detailed, after he's gone through that, if my lord looks at 106, I'm satisfied Dr. Sharp's opinion, omeprazole did not cause or contribute to E-sustaining fractures, is made out. It is an expert opinion that I accept. The difficulty with that is it is closing a door when actually, one, Dr. Sharp's advice was, I don't think on the balance of probabilities, and like many of these experts, she does engage with that term rather than perhaps others that one sees in clinical language. At no point did Dr. Sharp say, and at other points in the judgment, the learned judge notes this, it's impossible. We are all as advocates aware of cases where outliers are put forward and judges are quite properly able, forgive me, to close that door, to labour the analogy, in fairly short order. This was an unusual case where there were a number of possible causes for an underlying bone fragility issue. And as per ground one, in addition to that, one had the circumstantial factor of the femoral fracture. It would have been open to the local authority to leave that factor neutral and to say, and to the judge, we don't know whether this was an accident or not, but we accept that we do not have the evidence to prove it as threshold. In fact, this learned judge went further. He accepted on the back of Dr. Olson's evidence that it was an accident. And therefore, on the binary test, he was bound to factor that in as another differential reason.
Am I right in thinking also that Dr. Sharp's evidence throughout was very properly not attempting to do the judge's job, but all her observations about probability and possibility were based on her own expertise, which was purely that of a pharmacologist, but actually a pharmacologist approaching it from an epidemiological point of view.
Yes.
Namely, here are these studies of large populations, and this is what they show. This is what they show.
Yes.
That is all she was saying. And of course, it's an important thing to be saying, but it's not attempting to say whether the balance of probabilities on this case.
Well, my lord, that is precisely the point. She was able to give some advice, and my lord notes that she is one of perhaps at least two obvious disciplines to advise on these issues, because as my lords and my lady will have seen in other cases of this sort, we will often go to endocrinologists to look at this. And Dr. Algrove, for example, has reported on precisely this issue in some of the reported case law before the learned judge in this case. But yes, the limits of her expertise, or rather her ability to advise, were clear. She didn't go beyond those. And she quite properly said, on the balance of probabilities. The difficulty that I note is that the learned judge, A, without leaving the door open, my phrase, when then looking at the parents' explanations and other issues such as the lack of a pain response, which was quite clearly an issue the judge had to deal with, effectively, and I know I may be straining figurative language, goes down the corridor of the medical evidence, closing one door at a time until we get to the end, and then looks at the parents' accounts. The difficulty, therefore, is that there is, on any view, a linear analysis in that approach. And secondly, the learned judge elides impermissibly the balance of probabilities, i.e., it's less likely than not, says Dr. Sharp, but I can't say that it's not possible. I recognise the limitations of the research. And frankly, it's not for me to comment as a pharmacologist on other aspects. And the learned judge then treats that as something that, as I said in our skeleton argument, he has to say either yes or no, rather than saying it's possible when I come to look at the evidence as a whole. That, effectively for me, is the mischief in this judgment that then carries through to the problems the learned judge has.
So what he should have said, but at the end of 1-1, instead of saying what he said, he should have said, you say, the medical evidence and the medical evidence suggests on a balance of probabilities that the child does not have bone fragility. But before I reach a final conclusion on that, I have to consider the rest of the evidence.
Yes. And my lord,
Which he says there's a conclusion.
Yes.
Which you then puts forward.
Yes. And my lord, I draw attention to the judgment of Mr. Justice Peter Jackson, as he then was, in the 2015 case of ReBR, which ironically, and this is the form and substance point about rehearsals of counsel's agreed summaries of law that then don't find their way into the judgment. Ironically, this judge does note ReBR and sets out the paragraph on which I rely. And I draw my lord's and my lady's attention in particular to paragraph 9 of ReBR, which is found in our skeleton argument at page 289 of the full bundle. And I do so because that makes the point for me. Possibilities A, B, and C, degrees of likelihood on medical evidence alone, are then informed by the judge's.
I'm sorry to interrupt.
My
What
lady,
paragraph if you're going
It's
on?
paragraph 9 of ReBR, which
Paragraph
really sets out-
19 of your skeleton argument,
Yes,
Thank you.
exactly. Middle of the
289.
page.
on page
Got it,
289.
thank you.
That, we say, is precisely the point and the issue with which this court is dealing today. And as my Lord Justice Baker noted, that also finds its way into the earlier judgments of Mr. Justice Charles, who picked up on exactly the same
Yeah.
point when advising on the content of expert instruction letters. Varying degrees of possibility, differential diagnoses to inform the court's factual determination. The other matter that I would like to raise, if I may, is a particular aspect of the judgment that we, with reference to ground 5, are concerned about. It flows, as I say, from the manner in which the judge approaches the medical evidence, but it is this. There was a 3-week fracture window. That fracture window bridged the end of the summer holidays. I call them that because the mother worked within a school. And the 6th, I hope I have that date right, of September. Forgive me, no, it wasn't. It was the 12th of
That is the end
September.
of summer holidays.
The point is that for the first half of that fracture window, the child was in the primary care of the parents. My client worked nights, and he would be returning home and taking over some of the care. But broadly speaking, the child was with the parents all the time. When the mother went back to work on the 6th of September, the earlier arrangement then started again, hence the grandfather or step-grandfather being involved as an intervener. Because by that time, the femoral fracture had gone. And he was then effectively being a childminder, I do him no disservice, I hope, for a significant chunk of 3 days a week.
3 mornings.
Yes. In addition, the grandmother would be present for the first hour or so of that before herself going. The reason I raise that, and it's been touched on by Mr. Bow, is that there is an illogicality when, as the judge says specifically in his judgment, at paragraph, forgive me if I can find it, the judge says that he cannot, early in the judgment, narrow the radiological time window that Dr. Olson gave to him. That meant that the judge was not looking solely at the period where the parents had primary care. It followed that when he came to look at the absence of a pain response, he was bound to look at what the grandparents had to say about that. Mr. Bow has touched on this and has said to my lords and my lady that the difficulty was the judge seemed to hold that up as something of a litmus test. Notwithstanding, and I draw my lords and my ladies' attention to this, the points made on behalf of the father by Miss Brown in the court below. And if I may draw my lords and my ladies' attention to that, you find that at paragraph 11, which is at page 032 of the supplemental bundle. This court will be well aware, as my lady has noted, with metaphyseal fractures it may be slightly different, but with shaft fractures, one might well expect, would normally, we know the paediatric evidence of Dr. Shenoy, expect to see a pain response, which put a parent on notice, if not that there was a fracture, that this child was in abnormal distress. But that opinion was qualified. It was qualified by Dr. Shenoy, as Miss Brown set out there for the court below. But the other matter that I wish to raise, of course, is that the learned judge did not find that the grandparents' evidence was incredible in any way. He accepted it, in short, and he, as my lords already noted, pushed back against any suggestion by the local authority that the grandparents had colluded. The learned judge was bound, therefore, to take into account that the grandparents, in what would either have been at the time or the aftermath of 2 long bone fractures of a child who was just beginning to pull to standing, had not noticed anything abnormal whatsoever. That is wholly absent from the judgment. And the concern I voice is where the judge attached such weight to the parents not noticing it, he was bound to consider the fact that the interveners had not noticed it either. My lords, I felt that those 2 points might be helpful to raise. Are there any other matters with which I can assist?
Not as far as I'm concerned.
Do you want to say anything about what this court should do if we allow the appeal?
Yes. My lord, thank you. The discussion with the exchanges with Mr. Bow earlier are ones that I echo. I do so for the following reasons. I accept that there are many cases where deficiencies in judgments lead inexorably back to a rehearing with agreed notes of expert evidence and a finessing of effectively what needs to be heard again by a judge. That builds in and will build in inordinate delay. But if that were where this picture took us, I would have to accept it. That would occur. My lords, my lady, I seek to argue that the evidence is amply clear that where we have a number of possible causes for bone fragility, where we have a femoral fracture accepted by the local authority and by the court as accidental, and in the context of this case, where there is not one of these signal markers, if you like, as Mr. Justice Peter Jackson put it in the NSPC checklist, which Mr. Bow has set out, and we echo, this court is entitled to come to the view that threshold is not crossed, and to determine the matter for itself. Lord, my lady, thank you.
Thank you very much. Yes, Mayor.
May I deal firstly with one matter about the order that was made in January and the information that certainly myself and my learned junior heard for the first time this morning about difficulty in the funding for what is loosely described as the viability assessment by Ms. Carboni, the resolutions type approach. We have no information available to us at the moment about the chain of emails that have been referred to and aren't able to ascertain an answer in time to give that to you now. But what we have been able to take instructions on during the course of the submissions thus far is, now having been made aware of that, the local authority have instructed us that there is agreement for the local authority to fund the screening assessment by Ms. Carboni. And so if that hasn't already been put into operation, that should be able to start swiftly. But if there thereafter remain problems over funding, they will review whether they will consider funding the full assessment once they know what the content of the viability assessment is. And may I just very briefly touch on what was known, as I understand it, to the parties in terms of being information provided by the judge as to potential delay for his judgment. Obviously, these were care proceedings, so there was no open court part of that address, but the parties were certainly made aware of a planned period of leave for personal matters. But the rest of the information was provided, as we understand it, in the private emails that have already been referred to on behalf of my learned friend, Mr. Bow. Can I then turn to some of the broader matters that are raised by the judgment and the basis of the appeal? The judge himself indicates in his judgment that he had had some substantial dealing with the case management for this case, and in fact I think it's right to say that he had been the main case management judge from the point of the making of the interim care order, so that's the 8th of October of 2021. Now we draw attention to that at this stage to make it clear. And it's one of the reasons why we asked for the July judgment also to be included in the bundle, that this judge was very much alive throughout the whole process of the arguments that were being advanced on behalf of each of the parties. And obviously in particular, the stance that was being taken by the lay parent respondent, and that being that they had no explanation themselves in terms of a witness accident or an unwitnessed accident but coming upon the aftermath, that their case was that there must be a medical explanation unidentified by the experts, and that they pointed to a number of factors that may have given weight to the idea that there was fragility in this child's bones. He was aware of that from the outset, and he rehearses that in that July judgment as well. So it's not that he has ignored the strands of that argument, and it's very difficult to accept on behalf of this judge, who is an experienced family practitioner in public law work. It's difficult to accept that, having reminded himself, as we say that he does, appropriately in both the July and in the November judgments, of the tests, the key questions, and the key factors of the parent's case, that he in some way then simply fails to address his mind to that in the round, and simply in coming to the conclusions that he sets out in what inevitably has to be a form of written structured judgment, somehow approaches it in such a linear fashion that he has ignored those key points. And we say that the attack that has been made upon his judgment is one that is effectively focusing on precise wording, rather than giving the judgment itself the credit of looking at it as a whole.
Do you accept he concluded that the child did not have bone fragility on the basis of the medical evidence alone?
No. And I think we've pointed out in our skeleton argument that although he may deal with the specific key points of prematurity, feeding difficulties, and use of, I knew I'd get it wrong, use of the drug, that he does in each case ensure that he himself has paid attention to the fact he must step back and look at the combined effect of all of the evidence, medical and lay. And he includes in that not just the lay evidence of the parents themselves, but also the extended family. And so we accept, as inevitably I'm sure, each and every judge giving a judgment, that there may be times where a judgment can be better worded, but we do not accept that better wording is an indication that he has failed in the exercise that he has to undertake. Nor do we accept on his behalf that he has reached a conclusion which on the same evidence no reasonable judge could have reached. And that is an important consideration for this court. So when we look at those paragraphs where he deals in the judgment specifically with those three areas, you must consider under the heading of omeprazole those paragraphs from 56 through to 62. Which appears before he then goes on to consider brain fragility under the heading of his discussion and analysis. My apologies. Paragraph 56 starts at Appeal Bundle 99. So he considers that before he then goes on and considers the arguments in relation to brain fragility, which we see at App 104, so the appeal bundle, page 104, and then starting at paragraph 79. And we say that it's not only at paragraph 80, but there are many other paragraphs where he uses language which enables this court to see that he has considered not only individual but cumulative effects of the arguments that are put on behalf of the parent. So in paragraph 80, at page 104, he identifies the four potential strands. He does not identify them as being mutually exclusive. He does not identify them as being one that he must consider and only then consider the others if he rejects it. We say that he does in that paragraph indicate that he is approaching that exercise in the round of a cumulative effect. And then under the heading of prematurity, he then goes on to consider at 81 to 83 on page 105 the relevance of particular pieces of evidence, and main in this area, the evidence of Dr. Shenoy. But at paragraph 84, he says, having considered the totality of the evidence, and we say you can't, at that stage, read that as to only mean the medical evidence in the case.
He doesn't refer to it in the preceding paragraphs.
My apologies?
He doesn't refer to anything except Dr. Shenoy's evidence in the paragraphs leading up to 84.
Not in the immediate preceding paragraphs, but he does, for example, at paragraph 73 at page 103, which precedes that part of the judgment, accept the submissions about the wider canvas evidence and the particular features that are relied upon on behalf of the mother. He also includes at paragraph 74 consideration of the fact that there was a femoral fracture.
Where does he refer to that?
Paragraph
74,
74 at page 103. And then he also, at paragraph 75, puts the counter points to that, which is that these were two shin fractures in unknown circumstances in the care of her loving family. And that's not something that's disputed, obviously, by the respondents to the care proceedings, the appellant and the respondent father in this appeal hearing. So although it appears if you pick out just one paragraph or one line, that in the immediate preceding few lines he may not have considered matters, you do have to look at the judgment as a whole, because he clearly has in mind all of those other features at various stages through the judgment. And so when there are references to totality or whole, we say you cannot read into that unless explicitly stated immediately beforehand that he is reliant only on medical evidence.
He doesn't use the phrase totality in paragraph 110, though, does he? That's where he reaches his conclusion.
My lord, in paragraph 110, no, but again, in the lead-up paragraphs to that, we say he clearly has shown that he has stepped back and looked at the totality of the evidence. We can see, for example, again, preceding that paragraph 110, at paragraph 87, him factoring in clinical evidence. So not expert medical evidence, but clinical evidence on the progress of this.
Which paragraph are you referring back to?
My apologies. Paragraph 87 at page 106. So the clinical
Did you
evidence.
say 87?
I did.
On the 12th of July 2021.
Yes. So this is part of the history, because it's obviously presented that this was a baby who was in hospital for a significant period of time on omeprazole. It's also a baby who was making good progress post-relief, post-discharge from hospital. And he gives information there from the clinical records that were available to him. We can see also at paragraph 89, if you follow that through, that he's paying attention to the lay evidence about the descriptions of the child and how she was presenting. But also, because it gets factored in, we say, to the pain response that he relies on, that is also under attack, the descriptions of both the mother and also maternal grandmother as to how, in fact, this baby was presenting in the lead up to her presentation in September. So to pluck out paragraph 110 on its own with respect, my lord, is to ignore the fact that he's already factored into earlier passages of his judgment information that we say he clearly takes into account. Yes, it may be worded better, but that is not the same as having ignored or having conducted the exercise in an incorrect fashion. And I'm sorry to jump around in the judgment, but inevitably, because of the way it's structured and the way that the challenge is raised, I must do so. But can I also go back to a point that has exercised my lords and my lady, which is in relation to mechanism. Clearly, a judge does not have to set out where there is agreed evidence, not challenged, about potential mechanisms. But we say that he does set out, albeit it comes under the heading, firstly, if I find the correct page, at page 86, under the heading of what formed part of the local authority closing submissions. And if we look,
Sorry, this is page 86.
Page 86, and it's paragraph 21, but it's the sub-paragraphs on page 86. So 21E, he sets out this: local authority relies on the unchallenged opinion of Dr. Olson that in a child with otherwise normal bones, fractures do not occur spontaneously. You can see at the end of that little paragraph E, the mechanism that had been described by Dr. Olson if this was a child with normal bone structure, which is unnatural bending or twisting of Eloise's legs. And then you can see in paragraph F, he rehearses that should the court find that she did have fragile bones, then Dr. Shenoy, as did Dr. Olson, accepted that weight-bearing or minimal activity could have been sufficient to cause the tibial fractures. And then
But
again,
these are your submissions.
those were the
This
local...
is recording the local authority's
It
submissions.
is, my lady. Can I approach that in 2 points? It was agreed medical evidence, so those submissions are not controversial. Dr. Olson was not challenged by anybody about mechanism, either in a background of fragile bones or in a background of a child with ordinary bones. And my lady has also taken my friend to the point where the judge accepted the description is given by the father in interview of potential causation for the shin fractures, such as the jumperoo, such as the forceful stamping on the floor. But also, in terms of mechanism, if I can take you to, bear with me 1 moment. No. Paragraph 50, he then returns to this effectively, because although not in as much detail.
Paragraph 50,
Paragraph 50 of
page 97.
Insofar as agreed matters emanating from the expert evidence, those appear to me to be able to be summarised as follows. You can see at little paragraph C, Dr. Olson's opinion regarding force and mechanism for the shin fractures, if there were no bone fragility, and then he sets out there. And he has accepted in his analysis of the medical evidence, as already indicated, that if this were against a background of bone fragility, then the handling normal handling or near normal handling may be a cause. So all of those are types of information that he's already given consideration to, albeit under different headings, when he comes to paragraph 110 and his conclusions as to the fact that this is a child who did not suffer from bone fragility.
Are these paragraphs, go back to page 86,
Yes.
is this an accurate summary of the local authorities?
In relation to subparagraph E and
I mean, the way it's set out there is linear, isn't it?
the way
it's set out there is linear, and I'm not entirely sure that's how your junior put it.
my lord,
I mean, he says that your submission was that the child did not have bone fragility,
yes.
and that's, and as it were, that's a, it's described as being a building block in the approach. In other words, that the way Mr. Sampson was putting it. But is that how you put it? That he could reach a conclusion that the child did not have bone fragility on the basis of the medical evidence?
If that's a question as to in relation to the medical evidence alone, no. And clearly we say that the judge had to have consideration to the entirety of the evidence, not just the expert evidence in front of the court. But that the medical evidence, such as it was, certainly did not preclude him finding that the child did not have bone fragility.
Just trying, the medical evidence did not preclude.
Yes, he's not flying in the face of either the clinical or expert evidence when he comes to a conclusion that this child did not suffer from bone fragility. I hope that explains my point. Clearly he's entitled to accept medical evidence and give reasons for it if he does not and seeks to depart from medical evidence. In this case, we say there was nothing in the medical evidence that this judge has accepted that he should not have done so when looking at the case in its entirety.
Well, the medical evidence by itself was on the basis of relative, and this is my summary, relatively thin research, my characterisation of it, on a balance of probabilities, by itself, this was unlikely to be a case of bone fragility. That was the medical evidence.
Yes.
And I don't think the local authority was disagreeing, was putting it any more strongly than that before the judge. But the finding about bone fragility could not be determined until the medical evidence, could it?
No, and I think I've already accepted that, my lord. It's the way in which I take you back to earlier paragraphs, but then also subsequent paragraphs, where we say that the judge acknowledges that and does in fact rely on the totality of the evidence when looking at it as a whole. And into that obviously becomes the evidence not from Dr. Sharp, but from Dr. Shenoy, the paediatrician, about a pain response. He is entitled to look at that, and he is entitled, and properly so on the evidence that he's heard about the pain response to the femoral fracture, to say that this is a child who does respond to injury in an accepted and reasonable manner, which is immediate response by way of a pain reaction, a cry, a change in behaviour, and that he's entitled to factor that known response in when he comes to look at the idea that when she sustained either on two separate or one occasion the fractures to her shin bones, that he is entitled to expect there would be a pain response. He then has to look at, against that, but not necessarily to overturn it. He has to look at in the whole what the evidence, the lay evidence and the clinical evidence about that is. Now, it's been suggested that he hasn't factored in the pain response of people treating this child at hospital in September when the fractured femur is known. But with respect, that's not that reliable an argument against his assessment that she would demonstrate pain at the time of the injury, and in his words, his finding for some unspecified time immediately thereafter.
So, do you accept that the point made by Mr. Sampson that, that this child had a number of carers in the family, none of whom noticed a pain response? What would have been the she?
My lord, we accept that this child has been cared for by a number of members of the family. The judge, in his judgment, in specifically considering the maternal step-grandfather and maternal grandmother, identifies the limitations of the periods that they were caring for this child.
Sorry, you're letting your voice drop.
My apologies.
Identified the what?
Limitations,
the limitations
of
of the period, right.
the time periods that they were caring for the child. And my lord, we would accept that in the beginning of the time window for shin fractures, the likelihood is that the parents were the main carers for the child, with reduced opportunity thereafter towards the end of that fracture window for it to be wholly in the care of maternal grandmother or step-grandfather. But we can't say that there isn't a crossover of that. And we accept that the judge has made findings that we haven't sought to challenge on the appeal, that he accepted the evidence from maternal grandmother and step-grandfather in terms of what they observed. There is the caveat that my lord has already referred to in relation to rose-tinted spectacles, which not specified as to what that actually means, but clearly is an indication that he was concerned that although honest and as accurate and helpful as they could be, that there may have been some slippage in memory to encourage more positive memories than perhaps may have been the case. But I can take it no further than trying to explain that phrase that he's used. But what we have with this child is a baby, young child, who is not yet mobilising in terms of standing without support. She needs that support to be able to get up and then relies on that support to be able to move around on 2 feet. I accept obviously my lady's reference to the jumperoo, which is support from a mechanical means, and the stamping on the floor. But the court is entitled to rely on the fact that nobody has been able to describe an event where support was being given that was witnessed by them, where this child had another unusual pain response. He then factors in, when he considers this, that because of the evidence that he has heard about the attentiveness of this family, the picture that is presented to him is that she would not have been left unsupervised for any period of time. The picture also, as I've indicated, is presented to him of nobody having come and found the baby in an unusual position or exhibiting a pain response. The picture is also presented to him of nobody being able to say that this was a baby that was actually suffering from other conditions at the relevant time, so that she was crying for prolonged periods, so that she was demonstrating irritable behaviour on her arms and legs being moved. And those are the sorts of things that he is entitled in the whole to take into account, and that is perhaps significant by its absence. And he is allowed to weigh that in the balance when, as he indicates, the paediatric evidence helps him understand that it would be reasonable in the circumstances for this child to be a child that would exhibit a pain response, and reasonable in the context of what is known in the September presentation that she in fact did so. Relying thereafter on information about pain response is more difficult because clearly any individual pain response for this child may be masked by the pain response to the femur and by the pain relief that's presented at hospital. So we say he is entitled to look at those earlier features of the evidence, which includes both medical and lay evidence, and that he hasn't given that undue weight or looked at that purely based on the medical explanations for it. In relation to the evidence of Dr. Sharp, we say that he has been exceptionally careful in the way that he has looked at that evidence, and in particular, he's also been careful to understand the limits of the research papers. And he reminded himself about those limits. And if it is that it is being asserted on behalf of the father in support of the appeal, that effectively delay has played some part in the way that this judgment is worded, and I don't think that was presaged in the skeleton arguments that have been received before. We say that the court can see from various passages he has returned to and reread the research, the evidence, the case law, including the case law specifically, where cases are said to have a similar factual background with the use of PPIs and a risk of fracture. My lords, my lady, what we say in relation to the evidence from the research is that all of the factors that you were addressing with my learned friend Mr. Bow, which is that the research itself is limited, that the research has contradictory or not clear findings, uncertain, my apologies would be the best way to put it, uncertain findings, and that understanding the impact of the research obviously takes us beyond what is known about the precise features in each of the cases that the research studies considered, creates uncertainty which this judge is entitled to rely on to the extent that there is no clear causal link yet established between the use of PPI such as omeprazole and a heightened risk of fracture. There is an association which is not the same as a causal link, and Dr. Sharp's evidence on that point was clear. And we also say that Dr. Shenoy, in his oral evidence, when asked whether he could say that there was a causal link, he said no, he could not say that on the balance of probability.
Well, that's very common with these epidemiological studies.
Yes.
What they're there to do is to establish an association.
Yes.
And they're never in such causative, unless perhaps they're so strong that the only explanation can be causative. But they generally, in fact, this is putting it too widely, but they very commonly do have a causal explanation. What that means is, however, that people haven't yet identified a mechanism.
Yes.
Or certain mechanism, although in fact we see that from the Marconi paper that various plausible mechanisms are identified. So I think saying it's not causal isn't a great point. The fact there is a strong association is quite enough to go into the balance.
And he did put it into the balance.
Yes. But I'm not quite sure why you're emphasising the fact that it isn't causal. I mean, that's rare. With this kind of evidence, it rarely is causal.
But that's also a factor that he's entitled to take into account. If he had simply said it's not causal and therefore I put it to one side, we agree that he would have fell into error. He puts it amongst one of the factors that he takes from the evidence of Dr. Sharp. And that he sets, we say, quite carefully what he takes from Dr. Sharp's evidence. In paragraph 102, and he does so in those subparagraphs from A to L at pages 109 to 110. he there, we say, warns himself again about the fact that there is no direct comparison that he is able to rely on, or that indeed the expert herself is able to.
There's no real structure to this paragraph. Would you
My
accept that?
apologies.
Would you accept there's no real structure to this paragraph?
No, it's, in our respectful submission, it is a judge drawing out from the oral and written evidence those particular points that have played on his mind and in his balancing of the evidence that there is. But he also obviously comes to an assessment of Dr. Sharp as a witness. He comes to an assessment of Dr. Shenoy as a witness. And he is entitled, in his position as the ultimate arbiter of the facts, to draw conclusions based on the totality of that evidence that he's heard. He is not slavishly relying on particular points from the Malcody study. He refers to them, but he has warned himself as to the limits that they can be taken to. He also refers, for example, to the Wang study at little paragraph F. Dr. Sharp found that this did not show any statistically significant increased risk of lower limb fractures with the use of PPIs. And that's part of one of the areas where there are lack of consistency in what the studies show. And the studies are also...
Out of curiosity, why is that a lack of consistency?
My apologies, my lord.
Why is that a lack of consistency? I don't think the Malcody study specified where the fractures occurred, so there isn't an inconsistency.
All fractures over the entire length of the study.
Yes. So why is that a lack of consistency that the Wang study?
It's the difficulty in comparing
Oh, I
life
see.
with life.
Okay,
My
thank you.
apologies.
But the difficulty there as well is Dr. Sharp, as I understand it, discounted the much more recent study in Fleischmann on the basis that it was only 32,000 people and so on, and that very specifically did say that the PPI cohort was more likely to suffer from lower extremity fractures, which is in paediatric cases, which is a much more recent study.
Well, yes, he gives his reasons for saying that that was an acceptable approach because of the limited numbers, but it's not again something that is ignored in its entirety. And he has had the benefit, and I know this is a prime point, but he has had the benefit of what was, we would say, extensive cross-examination on these points. And yet, when looking at the evidence in its totality, has concluded that he is entitled to reject the idea that this child is suffering from fragile bones. And one of the features that we've mentioned in our skeleton argument, but hasn't yet featured, is that obviously this is a child who, as you've heard, was then in foster care from the 8th of October 21 and remains in foster care. And there has been no challenge to the proposition that's acknowledged by the judge in his evidence that there have been no further fractures. And that's including at a time when this child would have gone from the mobilising with support to mobilising under her own steam. And that is an important factor which does have to weigh in the balance if we are looking at whether it is a realistic proposition that the injuries to this child are down to bone fragility, or a combination of bone fragility plus the other features. And you have Dr. Shenoy's evidence of the other features about, although she was premature and had parental feeding, she didn't fall in the category of extreme prematurity. She didn't fall into the category of the length of parental feeding.
Parental, isn't it? Not parental.
My apologies, yes.
I
parental.
noticed the judge gets that wrong as well. So.
That's probably why I'm repeating it. But the feeding other than through the mouth normally, through the bottle or breastfeeding. So Dr. Shenoy was also somebody that he could rely on to say that I don't have to conclude that all of these things added together mean that there is a much greater increased risk. He has considered risk, he has considered the features, but on the evidence as a whole, he has rejected that as being a conclusion that he accepts for this child. And once he accepts that, having looked at the evidence as a whole, he's then entitled to go on as he does to consider causation in terms of who is responsible. The fact that his assessment of the parents' oral evidence only appears under the we say should not again be taken as an indicator that he only then comes to consider their oral evidence. We say that the lay evidence is woven into his thought processes even before he gets to that point in his written judgment. My lords, I'm probably going to be more than 5 minutes, and I wonder whether that might be a convenient point.
Well, I was actually saying 10 to, but
Oh, my apologies.
Rise now.
Yes.
Yes. In that
Right.
case, we'll sorry, I've
No,
now.
we're not going to. She's not looking around.
Yes, I mean, it looks as though we're going to comfortably finish apparently early afternoon.
I would have thought so, my lord.
So we'll sit again at 2. You'll be a little bit longer. We will hear from Miss Chadwick, but I suspect only
Very briefly, my lord.
indeed, and then reply. Yes. Well then, 2 o'clock.
Thank you, my lord.
Court rise, if able.